Being inspired by the legacy of the former president of the Czech Republic, Mr. Václav Havel, it was only natural that Czech presidency has decided to support and promote this event, focusing on the rule of law.
Let me namely welcome the President of the Flemish Bar Association, Mr. Peter Callens, Vice President of the German Federal Bar, Mr. Andrej Haug, the President of the Bar Association of Serbia, Mr. Dragoljub Đorđević, Director of the Czech Business Representation to EU, Mr. Pavel Zelenka, representatives of the European Commission, European Parliament, colleagues from the permanent representations of Germany, France, Sweden, Finland, Estonia, Poland, Croatia, Latvia, and the Czech Republic.
We will continue to promote the principles which we all hold dear, the principle of rule of law, during the rest of our presidency as well as we did during the first 4 months.
These initiatives are a very important contribution to fostering and promoting a rule of law culture. The rule of law, democracy and fundamental rights are the foundations on which the European Union is based, and as such they are part of our common identity. More specifically, the rule of law fulfills a specific function in the list of values referred to in Article 2 of the treaty, as it is the necessary precondition guaranteeing the protection of all other fundamental values. Therefore, the rule of law is of existential importance for the European Union, which is a community of law. It guarantees the effective application of Union law and plays a crucial role for the functioning of the EU, ensuring that member states and their citizens alike can work together in a spirit of mutual trust. Without mutual trust, there's no way that the Union can work. However, and as is well known, we have experienced developments where the rule of law is openly challenged, also within the confines of a union. These developments are and must be a matter of concern for everyone. And one specific and essential element in this context is also respect of the confidentiality of the relationship between clients and lawyers, which has been recognized and stressed also by the Council of Europe, as you very well know. This will be discussed later at length. At this point, just allow me to mention that the Commission is fully aware that confidentiality is generally subject to pressure and is following this very, very closely.
I welcome the fact that the 2022 report clearly mentions lawyers and their professional associations as players of a fundamental role in strengthening rule of law, ensuring the protection of fundamental rights, including the right of a fair trial, which is only completing the work we did in due time in delivering the so-called procedural guarantees package, namely access to lawyer, presumption of innocence, legal aid, which are fundamental pillars of the access to justice, fundamental right, and the right to a fair trial. Therefore, I can only once again underline the importance of having the independence of lawyers, legal professions, solicitors, barristers, legal professions, and bar associations in the annual report clearly covered for all EU member states, and any shortcoming in that regard be properly addressed by specific country recommendations, because the independence of legal professions is a guarantee of the access to justice and rule of law in itself. So any threat, pressure, or surveillance, illicit surveillance in violation of the so-called client-attorney privilege should be attentively monitored, controlled, and subject to scrutiny across the EU in all of its member states.
The reason why some of us lawyers and representatives of the bars are here today is to show our interest in the EU matters, because they have a great impact on national legislation, on our work and our lives. I have to admit that it is not an easy task to comprehend the legislative procedure in the EU and the whole EU machinery in addition to our daily duties. That is also why the Czech Bar Association and several other bars have established their representations here in Brussels, but even so, it requires thorough knowledge when it is possible to contribute to the discussions on the level of all three institutions which are involved in the legislative process, and which is vital for the understanding of the outcome. Allow me to say that we feel that sometimes not enough attention is to its internal legislative process, despite the fact that it is the Council that should bring together the positions of all member states, protecting their national interests and standards, and balancing historical traditions with the new incentives from the Commission and Parliament. It is not enough to rely on the expert opinions on the level of the ministries and governmental offices without broader discussion with the relevant stakeholders. When new legislation is being introduced on the national level, wider discussion with the stakeholders is required, otherwise the process would be challenged. The reasons are obvious. The positions of the institutions debated in the trilogues are very different, and it is necessary to have an opportunity to contribute at all stages. Therefore, we call for a structural dialogue, and we are ready to provide our expertise and views. The topics we choose for today's panel discussion are both examples where the dialogue is necessary, and let me start with the second panel. Professional secrecy is the cornerstone of the legal profession. The protection of the confidentiality of communication between clients and their lawyers arises either through the notion of the legal professional privilege or the obligation of the professional secrecy which is imposed upon us lawyers. But they both create the required relationship of mutual trust between the client and the lawyer, based on which the lawyer, who is bound by ethical and professional rules, may advise their clients in compliance with the law. Contrary to common misconception, the relationship of professional confidentiality is not intended to protect the lawyers, but to protect their clients. It is an essential condition that the client may rely on such privilege and may safely disclose all relevant information to the lawyer, based on which only the lawyer may provide its professional advice and representation.
The key message from the CCB is that the rule of law can only be secured when there is access to justice. And there can only be access to justice when there is an independent legal profession. That's a profession free from interference by government particularly, a profession that has its code of conduct that it sticks by, and in the next panel we'll be talking about confidentiality. We have a role clearly then in looking at changes in the law to see if the law changes are consistent with the rule of law. The recently announced 8th sanctions package was widely speculated about, and there was even a suggestion that it would go further than it has gone, and that it would ban the provision of legal services, including representation in tribunals and courts. Now, we wrote on behalf of our national bars to the Commission, pointing out that, in our opinion, if it went that far, it would be a violation of Article 47 of the Charter and Article 6 of the Convention. Well-intentioned measures brought in urgently in the case of Ukraine can have unforeseen side effects, and in some cases they can compromise confidentiality and legal professional privilege. That was not the intention, but if it is the effect, we need to seek amendments.
Again, in the Rule of Law report, we have anchored a dedicated chapter on the importance of bars, on the importance of lawyers, concrete recommendations that mainly focus on the access to justice, be it in legal aid, be it on other aspects, have been included in this year's edition of the Rule of Law.
Okay, and therefore the rule of law that they are in charge to defend on behalf of their client is at stake, specifically when they defend criminal clients, when they are representing their clients for criminal cases. And I think, in these special tasks, lawyers who are in charge of having the rule of law enforced and respected must receive, and they do receive, the support of the bars. In fact, the rule of law, it works, or I should say, on two legs. The lawyers, of course, but the bars also. And I think the two acting as being independent, and the lawyers need an independent bar, and they need the support of their bar to having the rule of law prevailing before the court. Once we will have the convention on the lawyers, the convention on lawyers and on the legal profession. The CCB is very much at the initiative in this. We have a special committee in the CCB working on the legal profession convention. The Council of Europe accepted the principle of this convention, and this is going to be the best tool ever in order to protect the legal profession and to protect through the legal profession the rule of law. I mean, this is just it. I mean, lawyers, legal profession, and rule of law. This just makes one thing, one item that will be much more and much better protected with the convention to come. I hope it will be adopted in the next coming month. Thank you.
But before we move any forward, I would ask Mr. Geyer to answer one question which was in particular addressed to you, I believe, and that what can be done so that the rule of law report covers not only EU member states but also EU institutions?
That's of course one of the $1 million questions that also comes from the European Parliament. I think it's one demand also in the Parliament's resolution that it should be broadened, basically the 28th chapter that would cover the EU institutions. But at this stage, I think it's, on the one hand, you would ask, how would we do that? So would the Commission be able to draft a report in the same way that we do, for example, about the Parliament, about the Council, and then about ourselves? So that's already, we would be a judge in our own respect, and the lawyers would say that does not work.
As otherwise, sanctions are, in my view, very understandable and, in my view, inevitable as a reaction to the aggression. Isn't it against the fundamental right of an individual and or an entity to legal advice if a legal advice to certain persons is prohibited? Concern second, isn't it against the same fundamental right if certain part of a legal service is exempted from the legal professional privilege?
The world is changing quickly. We are facing many challenges that this topic could quite easily lose its pace with the development of the world. Nowadays, given the rise of technologies and the provision of legal services and in judicial systems, it is not enough to see the concept of professional secrecy from the legal perspective only. Technical aspects are becoming more and more relevant.
Is this a real problem? The surveillance, if we talk about surveillance of lawyers, is that a real problem, or is that only something theoretically which we are concerned about? Well, unfortunately, it is a real problem. This is exactly what we want to create a mechanism to ensure that there is a kind of alert mechanism through proper identification of the lawyer's role, etc., that first of all service providers know what data is owned by which lawyer, and that they then can also provide this special protection.
The whole issue of legal professional privilege and professional secrecy is a very nuanced one. It's complicated. And there's one thing we know about populist politicians, it is they don't do nuance. The world is black and white. The world is full of good guys and bad guys. They don't deal with the meta requirements of privilege. There is a particular Belgian prosecutor whom I've shared a platform with on many occasions, and his standard speech is that, society requires to be protected from the bad guys, and I am here to protect you. Just give me the tools, i.e., override all these protections, and I'm like Dirty Harry, I will protect you. And he actually compares himself to Dirty Harry. One of the courtiers at the court of the Red Queen in Alice in Wonderland was a character called Humpty Dumpty. And Humpty Dumpty said, when I use a word, it means just what I choose it to mean, neither more nor less. The question is, said Alice, whether you can make words mean so many different things. The question is, said Humpty Dumpty, which is to be master, that's all. So really, you see, we're talking about who is to be master. Is it to be populist sentiment? Is it to be the Dirty Harry school of thought? Or perhaps there's something else. The true master is the rule of law. There was a late and great English judge, and as a Scotsman that sticks in my throat. There was a late and great English judge, Lord Denning, who once said, "Be you ever so high, the law is above you." And that's the value which we as lawyers and we in the CCBE are fighting for.
I'd like to thank you for the organization itself and for reminding us of a topic that is highly relevant. And for the evolution of law, which is hermeneutical in its nature, it's developing, evolving in ongoing dialogue and reinterpretation of the very same texts. The values like the protection of communication in between client and lawyer, and in broader sense the legal privilege, or even broader, the rule of law. The changing scene of the digital world might seem confusing. I hope you'll get to the conclusion that it's not necessarily like that. First, the protection of the lawyer-client relationship is one of the cornerstones of the rule of law. Second, the basic principles of this protection remain unchanged despite the evolution of technology. Third, they are not only prophets who see the future, and it's basically the commercial, which is going to be the third point. We are confronted with modified scene, and sometimes we are tempted to modify the original and well-founded values, but it's not the approach we should take. We should keep these values because they are important, and we should adapt the way how we use the new tools of the digital era so as we can maintain these old principles.
We shall not allow the new technology or even the legislative proposals blur the principles. The Article 41 of the regulation establishing the EPPO provides that suspects and accused persons, and as well as other persons involved in the EPPO proceedings, shall have all the procedural rights available to them under the applicable national law, plus it brings in the text of the Charter as a whole by the Article 41, paragraphs 1 and 5. As I hope, I still believe that there's no deliberate interception and keeping of content of communication between a lawyer and client from the side of law enforcement authorities, especially I'd speak about prosecution. But it shall be mentioned that due to the character, complexity and seriousness of crime investigated by the EPPO, lawyers are involved in criminal schemes more often than they would be involved in other types of crime. In the cross-border assistance in criminal matters, it used to be and still are the state authorities which guarantee that due process of law, collecting the evidence in the requested state according to the law and respect to the law. can the providers and private companies like Meta, Microsoft, or Telegram guarantee the same? This mechanism has also been established not only not to interfere in the other state's jurisdiction, but also as a guarantee that that evidence has been genuinely collected within the due process of law.
The political background is, of course, the state security interests cause pressure on the values of liberty and justice. And the second political background aspect is that we cannot rely on the member states' legislation. We cannot trust all member states in this field of protection, legal professional privileges. The fifth principle refers to the client's sphere. We need protection in the client's sphere as well. Of course, the attorney-client privilege must be protected in the private area of the client as well. It's unbelievable that in certain countries, certain documents are protected in the chambers of the lawyer, but the same letter which you find as a copy in the documents of the lawyer, you have sent it to the client, are not protected in the client's sphere. So we need a correspondence in this field as well. And the sixth principle is very easy. Lawyers should be protected completely as long they are acting as a lawyer. If I behave as a criminal, I'm not protected by legal professional privileges. But my clients are still protected by these principles. And the second area I would like simply to touch with one word, internal investigations. There we need clear definitions. Is it a traditional lawyer's activity which needs all the legal protection, or is it something different which might need a little bit lower standards of protection? And of course, I have promised to introduce a solution. The solution is EU legislation based on Article 82 to improve mutual trust in order to strengthen the principle of mutual recognition. We can establish minimum standards in this field, in criminal proceeding, very easily for the member states, for the Commission. The only little step which has to be done is to put it on the agenda. Please put it on the agenda. Thank you.
And now I have to ask you, Mr. Van Wallegooy, is the Commission going to prepare such a piece of legislation?
You know I cannot answer that. Obviously, this has to do with Russia's invasion of the Ukraine, which highlighted the effectiveness, or rather not so effectiveness, of sanctions, and the need to come up with an approximation of our criminal definitions. Not all member states actually have criminal definitions in place for the violation of sanctions, and also to approximate the penalties, which are also quite all over the place in the current context. However, and this is how I come to the topic of today, these offenses shall not be understood as in imposing an obligation on legal professionals to report information which is obtained in strict connection with judicial, and this is the sixth principle, I believe, Holger, if I got it right, administrative and arbitral proceedings. So legal advice should be, shall be, protected by professional privilege. This is how it is.
I think what is important to stress is that what we are advocating, and also the principles as laid out by Holger Matt and principles which we have been advocating, are very reasonable. We are asking for a due process, and I think there is nothing, so indirectly in your message was that certain surveillance measures are appropriate if lawyers undertake illegal activities. I mean, we are not contesting this, that lawyers, there can be certain individuals that are acting outside of the profession. It's not about this. We are asking for due process, and we are very surprised that we face a lot of opposition to this very reasonable request in different legislative files.
So there is a general rule: we have to enable the system to prosecute the possible criminal activities, but not to build a system around them.
Frankly, when I was getting ready for this event, I went through the recent cases in the Czech Republic, and I was really terrified.
And you need to listen to the practitioners in the Baltic states. It doesn't matter which Baltic states. It seems to be that in all 3 Baltic states there is the same issue. Legal privileges are simply not respected. They don't care. Police does not care. And prosecutors don't care. They don't care. And the problem is, the legal problem is, without any consequences.
Well, in the very same time, listening to you, I thought, well, there is a potential of very many beautiful preliminary references.
Building on your point that it's not necessarily a separate legal instrument on this area, initial step is that at least in the regular legal instruments that have an impact on the undermining of this principle, like I just mentioned, the e-evidence proposal.
Criminal procedural law. Yes, there is no general legal framework, but there is a specific legal basis to establish minimum standards, not common standards. I'm not talking about harmonization of procedural law. I'm talking about minimum standards, and we are talking about the field of mutual recognition, mutual trust, mutual recognition. This is Article 82.
That technology develops, principles stay, but at least in the digital world, their enforcement is not always effective. Thus, we call for expanding the EU protection of lawyer-client communication.
It's actually not the judge who has the last word, it's always the woman, so
let me, on behalf of the Czech Bar Association, once again, thank you all for taking the time out of your very busy lives to come here today and to speak with us, to share your thoughts, share your ideas, and for trying to make sure that we leave the world just a little more just than we found it. Thank you.